Welcome to our unit on investigation and getting the story. This material is going to be particularly important because it will be used for your final project in the course. Paralegals spend a lot of time gathering information. Suppose a client who was injured in a car accident wants to file a lawsuit to recover damages for bodily injury, property damage, and loss of income. Before a lawsuit can be filed, an investigation must occur to identify all the parties who may have some responsibility for causing the accident. A paralegal conducting the investigation would attempt to locate all the parties who may have responsibility for causing the accident. This would involve locating and interviewing drivers of the vehicles involved, any bystanders who might have witnessed the accident, searching governmental records to determine whether other accidents may have occurred at the same location, and this could signal perhaps a dangerous condition that the municipality might be responsible for. A paralegal may use a database to determine whether there was a possible safety record of the types of cars involved. So are there any recalls that might apply? A paralegal might visit the scene of the accident to make photos or look for skid marks or search for any other physical evidence. This same paralegal might gather medical records and more. So as you can see, paralegals must develop basic information gathering skills. So this unit is going to introduce how to tailor a search for information, organize and record information, and identify sources of information. And it's important to keep a perspective here. This is an introduction. These are skills that will develop as you continue your studies, and you'll even fine-tune these skills in practice. So it's important to remember, practice is what's going to make you skilled in this regard. So let's first look at tailoring a search for information. And here we're going to essentially be dealing with the rules of evidence. But before you can actually utilize information gathering skills, a paralegal must make some determination as to the precise information that needs to be gathered. So it's prudent when you're given a memorandum or a task by your supervisor to take time to focus on the purpose for gathering information. So this would involve literally a brainstorming phase. You're going to sit down with the case file, the information that you have, and you're going to then focus on what information would be relevant to gathering information under these circumstances. What information is relevant to the circumstances? And by focusing on your purpose for gathering information, you'll eliminate possible areas of inquiry which are irrelevant, which then would put you in a position, if you're searching for irrelevant information, you're not being ethical because you're not being as efficient and effective as possible. So the bottom line is you're going to take time to concentrate and focus your time and energy on finding information that you need to know. And this actually leads us to the rules of evidence. I'd like you to recall back to our first lesson when we looked at the various classifications of law, which included a distinction between substantive law and procedural law. When we're dealing with the rules of evidence, we're looking at procedure, and you're looking at what information that would be admissible should a legal matter make its way to the litigation process. So the judge or the jury, and if you're dealing with what is called a bench trial, there will be no jury, and the judge is going to be the trier of fact. Or if there is a jury, the jury is a trier of fact. So the judge or the jury will make a determination on the basis of the evidence that the parties present to prove their version of facts. And most of this evidence is going to come by way of witnesses, testimony, documents, or physical objects. So as a paralegal tasked with investigation, it's going to be your job to search and locate admissible evidence. Your admissible evidence is going to be governed by your rules of evidence. There are what we know as federal rules of evidence. Again, you look at the distinctions of the law you learned in the beginning of the course. Another distinction is federal or state. So when we're looking at federal rules of evidence, they will apply in your federal court systems. And then note your states will have their own procedural rules. While there are some distinctions between the various states and the federal system, there are some common aspects which we'll focus on in our investigation material. So what you're really going to be looking for is information that has relevance, so your relevant information, and information that is reliable. So in order for evidence to be admissible, it must be relevant. Evidence is considered relevant if it tends to prove or disprove the existence of a fact that is important in resolving this dispute in question. So let's say, for an example, your client is injured and they have shared with you that they have whiplash. Medical records that would prove the whiplash would be relevant. So you would want to obtain an authorization so those records could be released to the firm, and then you actually get those documents. So you're searching for relevant information. Information also has to be reliable in order for it to be admissible. Evidence is considered to be sufficiently reliable if it meets the evidentiary rule requirements. So just to give you some idea of what you're looking at here is information will be reliable if it is coming from testimony from a person with what is called personal knowledge. The testimony must be based on personal first-hand knowledge of the facts to which the witness is testifying. So prior to actually a court proceeding, you might get witness statements, for example. So if you go back to the whiplash facts, if we talk to the doctor who actually, and again, you would need a waiver for this from the client, but if you actually talk to the doctor that treated the client, so they would have firsthand knowledge of the records that they had written. So is that information reliable? So since a witness testimony is concerning facts that might be admissible based on firsthand observation, it's important to find out not only what the witness knows, but also how the witness knows it. There are a lot of evidentiary rules centered around opinions. So suffice it now to say that expert opinions, and if you have an expert that has been clarified an expert through the evidentiary process, that would be useful information as well. You'll learn in your litigation course about your evidence and procedure rules. So you'll learn about hearsay and the importance of information being able to be tested through cross examination. So again, this is just an introduction. You need to focus on the purpose of your investigation in gathering what is admissible evidence. And you want to be efficient when you're going through that process. The next step, after information is gathered, you have to organize it, record it. So information that is obtained through an interview is of little use if you don't get a document or if you don't document it. So what you're going to need is a systematic way of documenting the information. So you want to look to see if your law office has any particular formats that they use. For example, you might see a narrative memorandum where the information obtained at the interview is presented in the form of a third-party narrative. And these are typically arranged in chronological order. So you just tell the information in order chronologically as it was obtained. There may be a client intake memorandum, which the paralegal would prepare. Again, these may vary in formats, but they usually contain the basic information about the client, a third-party narrative, and interview or comments. So are there any particular comments that you would provide based on your dealings and assessment of the client? There may be witness statements presented in a narrative form, but the bottom line in all these instances is you gather information through the various individuals that you would be interviewing or taking statements from, and then you reduce those to writing and they become a part of the case file. You may be required to obtain documents. For example, if you're working in a estates and probate case and there's a death involved, you might need to reach out to the governmental agency. So there are various governmental agencies that we'll get to in the next section that house various records. So the Department of Vital Statistics will contain information such as death certificates, birth certificates, marriage certificates. So you might need a death certificate. You go to the website, they actually have a form, and you would fill that out, obtain the information, and then that becomes part of the case file. So it's documenting the actual death would be an example. So you have to gather information and organize it. Another part of investigation is identifying sources of information. And there are a variety of sources. The three most common used for information gathering are governmental records, computer databases, and physical evidence. So it's when we're looking at governmental records, there's an amazing amount of information that can be obtained from governmental agencies. And most of these records are available for inspection by the general public. As you move forward in your legal studies, in various classes, you'll learn about the different databases that pertain to those particular topics of law. So for example, in your real estate law class, you'll learn how to search governmental records that deal with mortgages, deeds, and various liens on property, which is all available to the public. So the question you're going to have is there a useful governmental record in existence? And that might take you to, you'll have to conduct a little research perhaps to find that out. So you might need to search a statute to determine if there is a reporting requirement for a particular agency. And then from there, you'll know there's one in existence. You'll get an agency name. From that, you can then go to a website, search for general information where you could call and make an inquiry, or send an email and make an inquiry about how to gather various documents. So generally, government records exist on all levels of government and contain information on a whole host of subjects. It's going to be worthwhile for you to consider when you're doing your investigation whether a useful government record exists. And then you're going to try to contact the agency to find out what information is available to you from their files, gather that information, and then bring it and make it a part of your in-house case file. Again, and it's going to need to be information that is relevant, and some examples are birth, marriage, death records, driving records, professional licensing records, records relating to court proceedings, such as using Maryland case search. So keep in mind, you can use government records when you research. Another option is using computer databases. The internet has made databases increasingly accessible and affordable. So you'll want to determine if there are any computer databases available. So paralegals working in various fields may work with specialized databases routinely. So for example, if you're doing personal injury, medical malpractice litigation, you might use Metis, which is an online database for medical journals, newsletters, and textbooks. So essentially what you're going to do is look for supervision, do a little research on your own to get to the information that you need. So are there any databases out there? Westlaw and Lexis will also provide you with some good computerized resources for information gathering, as well as traditional legal research. Finally, there may be physical evidence that you would need to gather. As a paralegal, you might be asked to visit a scene of an event, and you might do that alone or with a witness. But once you're on a scene, you will need to make a record of any information that you see or gather. So for example, you might look for, are there any physical objects that would have played a part in the case at hand? You might literally take photos, draw a diagram. Again, it doesn't have to be to scale, but it's to give you some idea. There'll be experts that would draw diagrams to scale should they need to go to trial. Are there any skid marks in the area if it was a car accident? You examine the scene. What's going on around the area that the incident occurred? Is there any construction? If so, do you need to walk over and ask any of the construction workers, how long have they been there? Did they witness an accident that occurred on, and give them the date, and you might gather an actual witness that way. There may be some debris. So you're essentially doing a walkthrough of the physical site where an incident occurred. The idea is to obtain the maximum amount of information that you can based on your level of expertise. And then should you need to bring in experts to gather additional information, you share that with your supervising attorney. So to restate, practice makes perfect. It's impossible to catalog all the ways paralegals use information gathering skills. So what you'll be doing in this course to help you start practicing is conducting an investigation. Your investigation instructions are going to come to you by way of a memo from your supervising attorney. It's posted in the assignment folder. You have detailed instructions, which include a suggested time management plan so that you can wrap your head around how long the various activities should take. So this isn't an extensively long activity, but it is critically important that you give each portion of it the appropriate amount of time. As you work through, you are under the supervision of your supervising attorney. I, as the instructor, will be playing that role. So if you have questions along the way, seek supervision. And we'll be doing that by email. So we'll have a record of your questions or any lines of inquiry as you go along. You will be, again, given the instructional memo from your attorney. You have information regarding your client. You will need to conduct a client interview. So use the interviewing skills that you were presented with in a prior lesson. Interview the client and let the investigation take you where it does. You'll need to gather relevant information, and it is pertinent that you treat this as if it's real. Avoid unauthorized practice of law. So do not give legal advice. Get information, don't give information. Again, if you have questions, refer back to your supervisor. You will document your findings and track your time. It's imperative that you start this exercise immediately, as there's limited access to your client, and you will need to conduct the interview in order to move forward in the process. More than anything, I want you to enjoy learning this skill set, and keep in mind this is preparing you to work with actual clients, which you will be have the opportunity to do while you're in the program. Again, let me know if you have any questions.